Further discussion, Representative Mazzochi.
Thank you, Mr. Speaker. May I remove my mask?
Yes, you may.
All right. Thank you. Will the sponsor yield?
In case you'll yield.
All right. Leader Gable, because courts may not be familiar with our rules, do you dispute that for Amendment 2, which you said was the technical predecessor to Amendment 3, there were over 53,280 people who filed witness slips in opposition to your bill?
I don't dispute that.
All right. Now, Leader Gable, one of the reasons you stated Illinois needs this legislation was to clarify existing law because people are using the Healthcare Right of Conscience Act in a way that wasn't intended. But you do realize that with all of the various amendment switches you've done here, you're actually muddying the legislative intent that will be applied to your legislation. Do you realize that?
I don't agree.
Well, do you know how courts use the amendment process when it comes to deciding what is in or what is not within a bill for purposes of legislative intent?
The amendment is clear and it clarifies.
Not against the background of Amendment 2, but we'll get to that. Now, you've said that the administration has indicated this bill was needed to clarify legislative intent. But are you aware that the approach litigants have been taking in court recently is the same interpretation and meaning for this legislation that has been in place for well over a decade when it comes to this act?
The courts are still deciding these lawsuits.
No, ma'am. In fact, if you're, well, let's try to get it this way. Are you changing the law, or are you just changing with this bill what you believe to be the legislative intent?
I'm clarifying the legislative intent.
And that's it.
Yes.
All right, so when a court sees this legislation, the court gets to stick with all of the rights that a person had before this bill. They're just going to know what they think the legislative intent was.
This doesn't affect any of their other rights under any other laws, particularly under federal laws.
No, I'm saying about this Illinois Rights of Conscience Act. So all we're doing is we're saying, hey, courts, here's a legislative intent you may want to take a look at if you care about legislative intent when you're applying this statute.
We're clarifying that this bill originally was passed to impact the health relationship between healthcare workers and patients.
All right, well, you know what? That's irrelevant because are you aware that in 2007, the federal courts...
Representative Stevens would give 3 minutes.
The federal courts specifically reviewed our Healthcare Right of Conscience Act in Vandersand v. Walmart Stores, Inc., 525 F sub 2nd 1052, Central District, Illinois, 2007, and concluded that the courts of Illinois do not need to resort to aids for construction of this act, such as legislative history, when the language of a statute is clear. Were you aware of that?
Yeah, this law is being used in a way it was not intended, and we are just correcting
I'm asking
that.
if you're aware of that court case, Leader Gable.
I am not aware of that.
All right, well, are you aware that in that same case, the court held that the language in our Healthcare Right of Conscience Act was abundantly clear, and, quote, that health care includes any phase of patient care, and specifically includes medication. The court has no need to resort to legislative history to understand the plain meaning of this text, and, quote, the court does not need to resort to legislative history to understand that the statute protects any person and that the plaintiff had stated a separate claim under state law, separate and apart from the Illinois Religious Freedom Restoration Act, as well as federal law claims. Were you aware of that?
Well, I've been informed that that court case was about reproductive rights in a healthcare setting. And
Well, that's not how the federal court interpreted it. The federal court, so was that misinformation by the federal court back in 2007? when the federal court wrote what I just quoted? Was it a bastardization of the law?
No.
Okay. Let's talk about an Illinois appellate court 4th district decision right here in Sangamon County, Morfitz Inc. versus Quinn. The court there explained that our Conscience Act was designed to bolster a person's exercise of their rights by, quote, offering protections to those who seek not to act in the healthcare setting. The court noted that this right not to act was a different kind of right, the right to refrain from acting, as compared to instances where people want to act, such as when engaging affirmatively in religious activity under the Illinois Religious Freedom Act. Now, there again, Governor Quinn, much like Governor Pritzker today, argued that the statute was ambiguous, asked the court to examine the legislative history to resolve that ambiguity. And the court again said no, because, quote, the statutory language itself, given its plain and ordinary meaning, is the best indication of legislative intent. And the court reiterated that when the statutory language is clear,
Representative, please. Representative Severns will give you his 3 minutes. And
the court
members, please keep the volume to a minimum. It's difficult for individuals to hear. Please proceed.
The court reiterated that when the statutory language is clear, we will give it effect without resorting to other aids of construction. Do you know what that means, Leader Gable?
Yes.
All right. Do you know what the court said that means?
Tell me.
The court said that means the plain and ordinary meaning of our Right of Conscience Act is that you cannot discriminate against anyone, quote, because of such person's conscientious refusal to receive, obtain, accept, perform, assist, counsel, suggest, recommend, refer, or participate in any way in any particular form of healthcare services contrary to his or her conscience.
So that case again was in a healthcare setting.
You don't think COVID is in a healthcare setting? Well, Leader Gable, here's the question. If that is settled law, why do you think this law requires clarification of the legislative intent?
Because it's being used outside of a healthcare setting.
It's not. In fact, the Morfitz versus Quinn decision continues, and again, I'll quote it, I'll leave out the citations. The Conscience Act instead states that personnel or entities may not be discriminated against or punished civilly or criminally if they make a conscience-based decision not to comply. And the court continued that the governor could not enforce his administrative rules against the plaintiff. So let's turn to your amendments and how and why they're taking away rights and making the legislative intent less, not more clear. Now, one thing you want to have happen with this bill is that you will want a court to look at this legislative history now in 2021 when interpreting the Illinois right of conscience, right?
Yes.
All right, but the courts have already said they think our existing statutory language is crystal clear, and they don't need to go behind the statute and look at any further legislative intent. True? That's what the prior court decisions have said.
It's being appealed.
No, I'm talking about prior court decisions. They're done. The two that I just mentioned, those are done.
Oh, those were in healthcare settings. They didn't apply in this kind of a situation at all. Those were long before what
That's
we're
actually
facing
not
right
true
now.
if you look at the crystal clear language of the statute, which already applies to private sector actors, employers, and private settings, not necessarily a healthcare employer. But let's assume that the court is going to actually look at the legislative intent for your bill, SB 1169. You agree that SB 1169 was originally a bill about making it easier for kids with IEPs to get access to career and technical education, right?
Representative McLaughlin gives the representative 3 minutes.
Do you know? You don't know. All right, well, that's what it said. So that had nothing to do with the Healthcare Right of Conscience Act. Now, House Amendment 1 to SB 1169 also had nothing to do with the Healthcare Right of Conscience Act either, right? It was just a shell?
Yes.
All right. So the first time we actually saw any substance for the Healthcare Right of Conscience Act was with Amendment number 2. And now you've got Amendment number 3. Let's talk about some of the differences in the language between Amendment 3 and Amendment 2 to SB 1169. One of the first changes you made between Amendments 2 and 3 is at Amendment 3, page 2, lines 1 to 2. Do you have that?
Yes.
All right. Now, the original language in Amendment 2 in a comparable position read, "It is not a violation of this act to enforce such measures or requirements, including by terminating employment or excluding individuals from a school, a place of employment, or public or private premises in response to noncompliance." True?
Yes.
All right, now in Amendment 3, you keep the language, "It is not a violation of this act to enforce such measures or requirements." Yes?
Yes.
All right, but what you did do was eliminate the language of including by terminating employment or excluding individuals from a school, a place of employment, or public or private premises in response to noncompliance, right?
Yes.
What was your intent when you took out the example of terminating employment?
We listened to the feedback in committee and we wanted to respond to that.
And explain that further. What feedback? So now, are you saying
We're
that
in
nobody can have their employment terminated in connection with any refusal in connection with any COVID-19 related issues?
Federal law still applies.
Right, under state law. Do you know? Or is your staff member just trying to tell you?
Yeah.
Maybe you should let her have the microphone.
This law does not determine if someone can be terminated or not.
All right, well, your original amendment, too, though, was being pretty transparent that your bill would let an employer fire someone for not doing whatever that employer wanted with regard to COVID-19, right?
They can do that now.
Okay, so even with your Amendment 3, you think an employer can still fire someone for not doing whatever that employer wants in regards to COVID-19, right?
Even if this law never existed, employers already can and already do set their own employee protocols regarding workplace safety.
Right, and before
including measures intended to stop the spread of COVID-19.
Right, and before your legislation, if an employer did that and an employee thought you were going too far, or the employer was going too far, they could sue using this act, the Right of Conscience Act, right?
Representative, this will be the final 3 minutes that will be allotted to you.
You can't make that decision.
I just
Speaker.
did.
object to that.
Representative, the final 3 minutes.
It's
Please
abusive.
please bring your marks to close.
Do you know the answer to that?
So that's true regardless.
All right, and when it
That's
comes to schools, you're also not being as transparent. Are you aware that a court can now say that because you took those provisions out from Amendment 2 to Amendment 3, then based on the feedback you said you got at committee, that those things are actually off the table? That in fact, people can still continue to use this law to object to those things by saying those are still rights of conscience. You thought you were going to keep them in, now you're taking them out.
Well, I disagree. All federal laws still apply.
No, you don't understand how state laws are going to get applied and how the courts actually use legislative intent. Well, let me go to the bill since the speaker is prematurely cutting me off.
To the bill.
I met a very nice lady at a pancake breakfast in my district, and when she and I talked, I asked her, are you vaccinated? She said, yes. I said, do you think other people should get vaccinated? She said, yes. I asked her, but do you think kids shouldn't be allowed to go to school unless they get vaccinated? And her answer was, oh no. I asked her, do you think government should be forcing people to get vaccinated if they refuse, or if it violates their right of conscience, or that their employers should be forcing that? And she said, no. She intuitively understood what over 53,000 people and counting who filled out witness slips against this bill are trying to tell the governor and this legislative body. Government is supposed to persuade, not force. Government is supposed to respect and protect our civil liberties, not disregard them. And that is because we are citizens, not subjects. If we're going to say that there are healthcare services that are so important that we need to mandate them, spit it out, say it plainly, and enact it into law using the regular legislative process. And then every single one of us can be accountable to the people back in our districts for the vote that we took. What we don't do is destroy the separation of powers. Let an executive order or even an executive threat become the equivalent of the legislative process. And then take away the very remedy that the little guy, the powerless, the poor, the people have against government, administrative, and corporate overreach when it comes to medical rights of conscience. Let's also be clear that in this state, this is an unprecedented effort to backdoor a vaccination mandate without any lines of accountability, including at the legislature, and without any escape valve for religious liberty. Every other vaccine mandate we have in the state of Illinois is specific, limited, was passed by the legislature after years of conclusive scientific proof of beneficial outcomes, and they all still allow for religious exemption or independent proof of immunity to satisfy the statute. You haven't even offered a reasonableness or scientific efficacy standard for what you're doing here. If you were being scientific, you'd be testing everyone in, for example, congregant care facilities. Because according to the September 16th, 2021 New England Journal of Medicine, vaccinated healthcare workers with breakthrough infections, even though they may have had mild symptoms, they had high viral loads and had prolonged viral shedding for up to 32 days after diagnosis. But the governor is not saying that even in his state facilities, he's not making those people test. So much for following the science. This legislation is designed to lead to absurd results where you can let an employer or any person employed by any unit of government in the state of Illinois force a person to do things, even things your doctor thinks is medically contraindicated, wrong, or harmful. And tonight, your yes vote means you've denied them a remedial claim. They get nothing in a court of law. That is contrary to the legislative intent of our Right of Conscience Act. I urge a no vote.